Hello and welcome to Unpublished Opinions, the Institute for Justice Roundtable podcast, a podcast where Institute for Justice attorneys give their unvarnished and unpublished opinions about the law. So this is a little bit of a reunion episode of sorts because we have two of our regular panelists who have not had time for this show in a while. It's inexcusable behavior. They are Anya Bidwell and Patrick Jaicomo, the leaders of IJ's project on immunity and accountability. They did have something going on at one of the courts on First Street in Washington, D.C. Patrick had a few things to say to the justices there. I'm sure he will have some stuff to say to us about how that went. So, and then Anya was kind of involved too. I think she was sitting at the table.
I was holding the bag.
I mean, what do you do? I've sat at the table as a second chair, but I mean, really, you're just kind of scribbling a few notes, right?
I was.
If you weren't there.
I think Anya was absorbing all of the anxiety at the whole table, which was nice. She was like a heat sink. And she also did basically hand me the strangest shaped little pieces of paper that pretty much dictated my entire rebuttal. So she was Johnny on the spot for sure.
I was organizing our collective effort, the three other lawyers who were sitting at the table, just collecting our notes and thinking, okay, this is worth passing on to Patrick. This is, there's no time for this. I was super nervous. It's very true. Barrett was announcing an opinion that's completely not related to our case, and I was copiously taking notes just to calm myself down.
So this is the oral argument, very important matter that Patrick argued a couple of weeks ago, Martin versus United States, about a wrong house raid and the Federal Claims Act and a whole bunch of other stuff. And so we're going to talk a bit about the case. If you want to get the full rundown, we'll put a link in the show notes, as always, to our case page. And of course, as we are recording this, we're waiting for the opinion because it was a very late in the term argument. Probably won't be till well into June, but who knows? But for now, we're just going to reflect on what it's like to do this argument. So this is the second argument Patrick has had with the justices of the United States Supreme Court. The other one, I think we've talked about on Unpublished Opinions before, was in a partly refurbished office during COVID. But now he actually got to go to the court. So, your reflections.
I will say that the difference between arguing over a triangular speakerphone and arguing in the actual Supreme Courthouse is a little bit different, and being able to see the reactions of the justices is also a little bit different. I am happy that one innovation of the COVID era has carried forward into the present day, which is the ending of the argument with each of the parties' attorneys doing the seriatim questioning from the justices. I think it provides a lot of opportunity to sort of wrap up things that were left unfinished because of the chaos of having a free-for-all argument. Which during COVID, there was none of that. It was all seriatim. But now that we're back to mostly normal, we have the free-for-all argument period, and then you have the seriatim at the end. And so I like that a lot. As far as observations go, obviously the pomp and circumstance of the fancy marble and the velvet curtains and all that is nice. And your mom gets to come watch you argue, and that's fun too. And some people get to see that you're a real lawyer and you're not just portraying one on social media. And so all of that is very nice.
Any fans stop for your autograph?
Yeah, actually, I did have a couple people come up and say hey, we follow you on Twitter, or a fan of the Institute for Justice. As I was walking out, I shook hands with Ajit Pai, who was in the courtroom for some reason, it was the former, FCC secretary who had the giant Reese's mug that he was always taking pictures with. And so there was a lot of that. And it's, obviously last time around, and I got to see Anya argue the year before and see these sort of things play out from, the second party perspective. But, there's reporters who are pulling you aside in the big fancy hall outside of the Supreme Court. And so it's a nice experience. And I think it's really great for the clients, too, to get to see that and feel like the vindication of literally making it to the highest court in the land and walking down the stairs, even though the Supreme Court is under major construction these days. And so honestly, from my perspective, doing it in person in the court is a lot easier. And I don't know how much of that is freighted with this being my second time and last time being surrounded in this sort of background anxiety of COVID and everything that was happening. But, being able to actually like look at somebody and interact is just necessarily very different than talking on the phone. I had, a legal mentor named Sarah who would always say, face-to-face is better. If you can't do face-to-face, talk on the phone. If you can't talk on the phone, then send an email. And it's because it's a lot easier to get, miscommunications and misread cues as you further attenuate away from the face-to-face. And so being able to look, the justice who's questioning you in the eyes is, it makes it a lot easier to, get their cues that you might not even be consciously picking up and respond to their reactions and whatever. So,
but the sort of being able to look in the eye is, not actually that common when you're arguing in circuit courts, because there justices or judges sit much farther from you than at the Supreme Court. I think that's kind of, can you talk about this a little bit? Like it's a feature of the Supreme Court room that you can actually look them in the eye.
Yeah. So it's kind of funny because obviously the Supreme Court, if you've never been, itself is a very like majestic building. Everything's made of marble and it's very fancy looking and ornate, and there's statues and busts everywhere. But when you're in the actual courtroom and you're kind of looking at where the lawyer stands versus where the court is, it's actually one of the more it's one of the cozier courtrooms that you'll be in. Oftentimes you'll be even in like a state appellate court or the circuit courts, and the judges will be 30 feet away from you up on a 10 or 15 foot dais, so you have to look up at them. And in the Supreme Court, you feel like you can almost reach out and touch them. I don't know what the actual distance is between you and the Chief Justice, but it can't be more than like 12 feet. And their dais isn't that high, so you don't feel like you're having to physically look up to them. And it's odd because it gives you, when you're there, it gives you the sense of like, oh, these are actually just people, and I'm having a conversation with people. And of course, they're important people, and they're very smart people.
Yeah.
But just having the realization that they are only people, I think it should be at least calming to most people who are, ramping up to what should be a sort of stressful experience. And I know that last year when Anya argued, the day before, we went and just watched the Supreme Court argument. And I think that settled her quite a bit because then she got to realize like, oh, there really are just 9 people who were very close. And it feels kind of a lot more like a conversation. And I always tell that to younger attorneys too, which is, if you just view oral argument as a conversation with other people, then that can be a way to, get the most out of it without feeling like you're putting on a performance, whether that is to impress people or as like a gesture to a king. I don't think that like either psychology of doing it that way is particularly helpful for you or the people you're talking to. So
and you really don't get it out of listening to Oyez app because, like Gorsuch tends to really sound pretty hostile on the app when you're just listening and without seeing him. And with Patrick too, I think if you listen to the argument without seeing it, he seems like he's going after Patrick, but you could see that in the moment, he's very much enjoying his exchange with Patrick. And Patrick kind of knows that. And so he is even comfortable cracking a joke. And he and Gorsuch have this understanding at the end of the exchange, which is really, really neat. But they're so close that you pretty much can give Chief Justice a cold. Like if you were sick, right, Patrick? Like if you were like talking to him and you were sick, I think you could give him a cold.
Yeah.
Yeah. So I never, of course, have argued at the Supreme Court, but I've seen a couple arguments, and I don't know if there must be, but I can't think of an appellate court where you're closer to the actual judges. And I'm sure someone's like done this and they took a tape measure at different courtrooms, and I don't know, maybe it's also because there's 9 of them, so they seem closer. I can say the Minnesota Supreme Court, where I've argued a couple times, you're kind of close, but you're definitely closer at the U.S. Supreme Court. And that does really, help with that whole conversation advice. I have to say about the advice to have a conversation, that is terrific advice. It is easy advice to give, and it is incredibly hard to execute, of course. So
no, I think that's true about most lawyer advice. It's just like, be confident and know all the stuff and answer the questions very directly, but also don't give anything away,
Write all topic sentences.
Right, exactly.
Yeah, well, sometimes it's not that easy.
Yeah. Don't say, none of that stuff. Just be direct, be as concise as you possibly can, answer the question, but don't fall into any traps. You know, it's like everything else. It's as good advice if you can take it and follow it.
Well, I do think it's easier. So when you're doing an oral argument, it is easier advice to try and have a conversation if you don't have like something you're trying to convince them of. And I think so it's harder when you're like, you know, you think coming in, this is going to be a hard case to win. So if you're coming in and you think you're looking pretty good and the briefing was good, and especially if you're the respondent, you think the court's going to affirm, and then you come, hey, judges, what do you want to talk about? Like, I remember I was involved in this case at the Seventh Circuit a long time ago, and the lead attorney came in and he just said, he was the respondent. We were feeling pretty confident. And he just comes in and says, Your Honors, have any questions? He didn't even have an opening. And he totally had this great conversation with the court, and we won. But it was because we were in a really good position. So if you're in a hard position, I mean, you can have a conversation, but you also have to know all your stuff and have great points to make, and then it's kind of less conversational.
I think even from the perspective of sort of savvy court watchers, but certainly for everybody who's listening to or watching an oral argument, so much of the determination of how well you did is how nice the court is to you and how agreeable they are with you. So you can be like one of the greatest of all time advocates in court. And if the court's upset about the case or the issues and they're just going after you and arguing with you vociferously, and then the other side gets the sort of the velvet glove treatment, then a lot of people come away from that and think, oh, you did a bad job. And it's actually just, you know, that's how the court was that day, or it didn't like your issues. Obviously, there are people that are more sophisticated than that, but I think just the sort of general vibe is people tend to think you did well if the court is nice to you, and vice versa, even though those things aren't especially correlated to your quality as an advocate.
That's very true. It does also help if you are a repeat advocate, like, say, Paul Clement, right? Where even if it's a very difficult position that he has to defend, they will give him grace because there is very much of an understanding that he has earned his right to have a conversation with them.
Unless you accuse the other side of lying, then you might not get that grace.
I don't know, unless it's Justice Kavanaugh, because Justice Kavanaugh, correct me if I'm wrong, listeners, but I don't think he's ever given a hard time to Lisa Blatt.
I think you get quite a bit of leeway. Yeah, for sure. And the other piece of it is it's like, okay, well, if you get dressed down and you're still winning your cases or you're getting your cert granted, then, you know, fine. I guess that's sort of that's the price you pay to be a lawyer. I used to tell people when I worked at a law firm, like, you know, you're basically paying me to take your stress and put it on myself. And so that's the same thing. It's like if you get up there and get smacked, but your case still gets, you know, you still win your case or you get your cert granted or whatever. It's like, sure, okay, I'm happy to take the licks for my client. But, you know, I think it also goes back to the sort of presumptions of regularity kind of stuff, where it's like, yeah, if you've seen someone come up and do a good job a few times, 10 times, 20, 50 times, there's going to be a lot more benefits of the doubt that they'll get. And there's just these sort of little pieces of the conversation that might be viewed as, you know, uncouth or too rude if it's some random person who's doing their first argument before the court. Whereas if you have somebody who's been there dozens of times, they're going to take it in stride.
So I'd like to dig into what you just said, presumption of regularity, which I don't know if you meant it in the way that it's often used, but, you know, in the last few months, the new administration, things happening in a different way than they used to. A lot of people have been talking about the presumption of regularity. And I have to say, the more I think about it, I don't really know what that means. And like my, you know, IJ libertarian mind, when I hear it, thinks, oh, it's kind of like the rational basis test. Like it means judges assuming that the government is on the up and up, essentially. The more I think about it, though, I think it just kind of gets tossed around as like, you know, we think that government lawyers are normal, which is kind of a different and more peculiar context. And so I also have to say, I've really only ever heard it used. And I've been around this kind of scene for a long time. I've really only heard that thrown around a lot right now. And then also during the first Trump administration a bit. I've barely ever heard it otherwise, which makes me think it actually isn't that big a thing.
It's a big thing in prosecutorial cases. So we dealt with it a lot preparing for Gonzalez's case.
So it is kind of like a doctrine when you're in that sphere.
It's so the difference between a police officer arresting somebody and there is probable cause, and whether you can sue that officer for an arrest, versus a prosecutor indicting somebody and there is a probable cause, is huge. And prosecutors are treated with much greater deference than police officers are. And there is this very much of an understanding that prosecutors need to exercise their discretion. They often have to choose between whom to indict and whom not to indict. And so we are not going to look into their decision making, and we are going to presume that they acted regularly. That presumption of regularity. And even, if you go back to 40s when Robert Jackson, he was a prosecutor, right? That's even before then, where he gave this big speech talking about presumption of regularity and saying that we as prosecutors are, have this protection that allows us essentially to get away with murder. So we really need to be, selective in how far we push.
But that's different than prosecutorial immunity, right?
Correct. It's different, yes.
So my 10-cent view of this is that you have this sort of background principle of this presumption of regularity that is being applied in some form or fashion to all government actions taken when they're being evaluated by a court. And I think the way that it manifests, like Anya said, in the prosecutorial context is this is always just an escape valve that the courts will use if they need to in one form or another, informally or informally, and actually stated or unstated. And so in the case of the prosecutorial immunity context, it's pretty clear the court's just making this stuff up out of whole cloth. And so the last sort of vestige of something seeming formal there is by saying, well, we presume regularity. And so that's kind of a basis for us to prevent you from suing this prosecutor. But I think in most cases, the presumption of regularity comes in the form of, like you said earlier, Anthony, just being willing to give the benefit of the doubt to the government or believe what they're telling you without really having any sort of confirmation of it. And I think that is unfortunately a thing that's pervasive, and it's probably something that is formalized and just as much as it's completely informal and pervasive in cases where the government's on one side of the V. And I think, one of the lessons that the courts have started learning, I think, in the last few months is maybe we should revisit whether there is such a presumption. And I would have said, of course, from the first day I was a lawyer, you should be treating the parties equally. The whole point of the adversarial process is for the parties to then make their own cases. And so putting a finger on the scale, whether it's a light finger or a heavy finger, seems completely inappropriate to me. So I would actually like to see the courts use this moment where now we've seen the government repeatedly involved in different chicanery and misleading statements and wiggling out of, well, technically this word could mean X, but everybody knew it meant Y, and all sorts of other bad behavior caused the court to shift its view on these things. And that's my read of what the Supreme Court just did in the AARP decision, is fundamentally the distinction between the 7-justice majority and the 2 dissenting justices was really about, do we believe the government when it said it wasn't going to transport these people out of the country and out of the reach of American courts? And the 7-justice majority, having seen what had happened in the Abrego Garcia case, said, no, actually, we don't believe them. And there was evidence that they were busing people to airplanes. And the 2 justices on the dissent said, well, we believe the government when they told the court that they weren't going to send anyone out of the country. And I think there are a million other kind of less meaty types of things like that these courts have seen and that they've heard from various representatives of the executive branch that have led them to be like, you know what? I think we're just going to take this extra weight off the one side of the scale and really kind of dig into this as if we were adjudicating things between 2 private litigants. Now, we're not all the way to that balance yet, but I think we're moving in that direction.
I mean, the universal injunctions case is another example of it, because if you listen to the argument, you could really hear kind of almost like the death of the 10th justice concept.
because they just did not trust Sauer to correctly represent what they were going to do. Especially that line of questioning with are you going to enforce a circuit court's decision? And he continued to refuse to answer, and they continued to press him on that. It really is a very different dynamic. So I agree that maybe if there is a silver lining, it's that.
Yeah, it was interesting too, because in the AARP conversation too, the Supreme Court was citing to the hearing that was in Judge Boasberg's court, which was not the thing on direct appeal in AARP. And what happened there was this request for emergency relief because they were busing these people to airplanes to fly them out of the country. And they actually took a recess where Judge Boasberg asked the DOJ attorney to go find out if they were planning to fly people out of the country. And after half an hour, he came back and said, I can represent that they're not going to take people out tonight. And there's no plans to take them out tomorrow, but DHS reserves the right and it thinks it would be legally permissible for them to do that. And so it's all this game of cat and mouse where they're kind of playing fast and loose and refusing to agree to certain conditions. And then that way, when they violate the sort of unspoken obligations that everyone assumed were at play, they can turn around and say, well, nobody said specifically we couldn't do that thing. And we've seen that now a bunch of different times in a bunch of different contexts, not just in the immigration context or the birthright citizen context, but, a bunch of these other cases, whether the government might be legally correct on the merits or not, it's taking this approach as a general matter in most of these cases.
So it sounds like presumption of regularity, and that, in the senses you guys are talking about it, is about government lawyers to judges. That's where it comes in. It's not so much we presume that some bureaucrat, when they're acting, is doing so in good faith, although there might be some other doctrine about that. And there's also, of course, the rational basis test, but then you have to be arguing about a right that gets rational basis. But it's just the idea that government lawyers are not going to, when I put it this way, it sounds kind of bizarre. Government lawyers will not lie to the court. Well, all lawyers are supposed to not lie to the court.
Right.
So what is the specialness of it?
And it's not just about lying to the court. It's also about presumption of regularity in that when a prosecutor is making a decision whom to prosecute and lets another person go, that we are not going to look into the exercise of that discussion. We're going to presume that. Well,
I get that. But that sounds different than, say, a lawyer saying, "Well, we're not flying anyone out tonight."
Yeah.
Right. And being
I
believed.
think that goes beyond that narrow definition for sure.
Yeah, I think Anya's right that it reaches a bunch of different stuff. And so when we're talking about it in the context of courts, it means, well, I'll make representations to the court in court and they'll take it very seriously. I think this is kind of what happened with de Villiers too, where you had the state of Texas completely change its position and say, oh no, actually they could potentially do this in state court. At once they said the opposite of that all the way through the appeal. And then you have the Supreme Court say, well, Texas said that the plaintiffs could do that and that's good enough for us.
Yeah. Yeah. And that was a cache they were able to check there because of that.
Yeah. And I think that happens all the time. And you can see just from that example how it usually seems kind of mundane or, unimportant, but then it can have enormously impactful effects. And the court will decide a case based on some sort of persuasive statement about something that the government might do in the future.
So I wonder then how much it maybe does kind of connect to, say, rational basis stuff. Because often in a rational basis case, right, you'll have the advocate for the government will argue, well, the legislature could have thought, this thing to do with public health and safety when this law was passed. When everyone knows, of course, it's not what anyone in the legislature was thinking about. And that's built into the test, is that you're supposed to, as a judge, be able to hypothesize those reasons. But the fact that an advocate is saying, oh, yes, that might have been what was actually said, or that it does further this interest, right? That's built. I think the fact that the lawyer is arguing that makes it kind of more palatable than like a judge coming up with. Judges do that in rational basis cases, but generally it is a flimsy rational basis that an advocate has given to the judge, not that the judge has given on their own. And I wonder if that connects then with a representation by a government lawyer is just, taken as the gold standard by the court. So, I mean, the like long range, hope might be the silver lining of this period is that if the presumption of regularity is falling, and when we're talking about deportations, is it going to have any effect on other ancillary matters like how the rational basis test works? Probably not. No, I got to say, but I mean, I wonder if there's something there.
I think you're right on the substance of how the test works in comparison to this presumption, but I don't think, I think no matter what they end up doing formally or informally with this presumption of regularity, it's not going to shift the actual, elements of a rational basis review, unfortunately. But I think the analogy in my mind is kind of like, if you hear about someone doing something stupid and it's just a stranger, you're going to think, oh, well, they must be stupid. They did something stupid. But if it's like a good friend of yours and you hear about them doing something stupid, you think, oh, well, Anya must have had a good reason for doing that. And it's that kind of thing where this goes to the point Anya was making earlier about how it works with prosecutors, which is like the courts aren't going to interrogate why the prosecutor did the thing. They're just going to assume that they must have had good reasons, and that's enough. And that's what rational basis is like too.
Yeah.
And there are different versions of this, and some are representations in court. Some are just, hey, we're not going to look behind the curtain to see who's running the Oz machine.
Yeah, that's exactly how it connects with me too. That it's essentially, we are going to presume you guys knew what you were doing, whether it's rational basis test or whether it's something else. It's very much that kind of idea that it's not up to us to second guess you because, we like you and we assume you did everything correctly.
Right. And I think that's part and parcel with the idea of the SG being the 10th justice too.
Yeah.
It's the same kind of thing, which is like, oh, well, the Solicitor General of the United States couldn't possibly come in here and just lie to us. And I think a lot of us of our political persuasion or ideological persuasion would say, yeah, they can, and they often do. But
what,
here we
I
are.
mean, I guess we're all sitting here like, why did it take something this ridiculous to, break that veil when government lawyers lie all the time?
I think there was an enormous value that was accorded to sort of the veneer of propriety that we've been living under for much of our lifetimes, which is like, even though the government would be doing bad things, it would come up with at least a colorable justification for why it was doing bad things instead of just being like, because I said so. And I feel like we're seeing a lot more moments of breaking through the veneer and just seeing the pure because I said so.
Mm. Well, I think that can bring us to the birthright citizenship, universal injunctions, whatever it was, or argument last week. So that, I think you could say that's a case where the Solicitor General did his best to try to keep up the veneer, although not drop, a lot of these arguments that have been made that do stretch credulity. But also, frankly, just kind of go for an argument, a policy argument, without and the policy argument being we shouldn't have universal injunctions, without apologizing for it. And so, to that extent, maybe it was a good tactic. But we all, have listened to the argument. I'm sure many listeners to this show have, or at least read about it. I've written about it a little bit, but I'm curious what your guys' reactions were, especially because you were just there a couple weeks before.
Well, first of all, shout out to Kelsey Corcoran. She argued on behalf of CASA in that case, the private litigants.
She did great.
She did amazing. And I do kind of, it transitioned nicely from our previous discussion because I do feel like Sauer had much less credibility with the justices than previous solicitors general, given the Trump administration's behavior since, its second term got started. But I think, to me, a big takeaway from that case is that the government kind of is okay with losing in this case as long as there is a rule that makes universal injunctions generally harder, right? If the court were to say, here's the rule, this case is outside of that rule, but now the Trump administration actually gets to take advantage of the rule that limits universal injunction, I think they are more than happy to take that loss. I'm just frankly hoping that there is supplemental briefing on the actual merits, because some of the justices seem to be like anxiously wanting to get to the merits, like Justice Gorsuch, and that they just leave the universal injunction question alone.
Yeah, well, I
after doing all that,
after doing all that.
Yeah, I mean, I think the fact that this wasn't based on the priors that we've seen in other concurrences and dissents from these justices. I think the fact that this didn't feel like a slam dunk for the universal injunction question itself speaks volumes about how much damage the government's done to its reputation with the courts in the last few months. Because I think if this was Elizabeth Preligar arguing 7 months ago, you would have gotten a very different court.
Yeah, who did argue against having universal injunctions.
Yeah.
Right.
It should be said. Yeah.
You would have gotten a much less hostile response from the whole court. But here, I mean, everybody had very probing and difficult questions for Solicitor General, not General Sauer, who didn't seem ready to field those at the beginning. And to Anya's point, of my read of his performance was he came in feeling fairly confident. And then it became immediately clear that there was a lot more skepticism on the court. And that confidence shifted into him trying to punt away from the actual question, and whether that's to get a rule or to avoid the issue altogether. By the time he got to rebuttal, he was trying to force the court into the question about the merits of birthright citizenship, which is not where he wanted to be at the beginning. And so what I took away from that was that he thought that he was losing on the universal injunctions point and was hoping that he could kind of get a mulligan by getting the court to say, let's do supplemental briefing on birthright citizenship, and then maybe we'll revisit, how this injunction question is actually before us, and maybe we should wait to decide it or whatever. It didn't strike me as things went according to the plans that he had laid. And yes, I completely agree with Anya. Kelsey's the best. Great work by her on CASA's behalf here. But I don't know what the Supreme Court will do, of course. It very well could still side with the government in some small or large way. But I think the way that the court received this argument, which they, of course, specially scheduled late after their normal term actually would normally extend, so sort of speaks volumes to what the court's thinking about its relationship and its new relationship with the executive branch at this point.
Yeah, I got the sense that maybe not none of the justices, but a lot of the justices had not maybe fully thought through what it would mean to get rid of universal injunctions, which for the benefit of our listeners might be a bit confused. So that would be a court order that orders the government to do or not to do something that goes beyond just the plaintiffs who are in the lawsuit. And I mean, for us at IJ, who deal with cases all the time, some of which we ask for an injunction that's you could consider universal beyond the, maybe not like the whole country, but beyond the parties in the case. And also sometimes we only ask for an injunction that involves the parties in the case because of the case is factually different. For us, it's like we kind of get the nuance, but I think probably most lawyers even don't get the nuance, and even judges. And especially when the Supreme Court, when you're not used to writing out injunctions, you're used to just, affirming or vacating or reversing stuff. So you could kind of see like the wheels in their heads spinning and being like, oh, well, then you could do class actions. Oh, but class actions are kind of hard. So would this make class actions easier? Oh, man, I hadn't thought about that.
Sauer keeps saying we have tools in a toolbox. And they're like, well, what exactly are those tools? They kept wanting for him to unpack it, to kind of reassure them that at least one of those tools, like maybe class actions, would be relatively reasonably easier. But he wasn't able to provide them with anything.
Well, I think his fatal flaw. I think his fatal flaw was when he said we would resist most of her class action in this case, or we are resisting it. Like we're not going to.
And also, I'm not. If we lose at the circuit court, I'm not saying that we're not going to follow it, but we might.
Right.
Yeah, no, I think this is part, related to what we've been talking about this whole time. But what Solicitor General Sauer was doing was something we see all the time, which is the government comes into court and it says, well, we should be allowed to do this clearly unjust and maybe illegal thing because of some procedural alternative or some other potential remedy that could be available. And then you'll see the court say, okay, we agree, this is really terrible, but maybe there's something else that could be done if the plaintiffs had only done X, Y, or Z instead. And so here, at least, the court was willing to interrogate. And we saw this happen actually in the Eighth Circuit argument that we just did in Muhammad, where the court pushed back on the government advocate and said, well, what would be available
I was
to
just
them?
thinking of that. Yeah.
And usually the courts will just say, oh, well, it's good enough that there might be something available. But here they wanted to pin that down. And as it turns out, as we all know, when you try to pin the government down on that, it won't agree that anything's available. And so it shows that this sort of ameliorative pointing at other alternatives thing is usually just a smokescreen, because we all know that when the other alternatives are raised, the government and until now, the courts would say, oh, well, actually, you can't do that either. Sorry, it's not our fault. Talk to Congress, talk to, whatever. And so here it was kind of refreshing to see justices from across the ideological spectrum pushing back on the SG and saying, well, if they can't do this, could they do that? And him kind of, trying to wiggle out of it, but ultimately saying, no, I don't think so. I don't think they could do anything. I think we just get to do whatever. Like we can shoot first and ask questions later, even if that means that there will be, irreparable harms like we've seen in a bunch of these different contexts.
Yeah, it was, a lot have been made also about how the SG conceded or said that if the Supreme Court rules on an issue, that it will follow that, right? Even if it's not an injunction. And at that point, to some extent, it doesn't matter if it's an injunction or not. Did you think that was as big? Like Jack Goldsmith wrote an essay. We thought that this was a big deal because it's essentially conceding to Cooper versus Aaron, which is a Supreme Court case where the Supreme Court said, we are the final answer on constitutional law. It's not just that we have an answer and the executive may have a different answer and we rule in this certain case, but we are the final arbiter of the Constitution, which, even a lot of folks in our line of work don't concede.
No, it's funny.
That seemed very tactical to concede that, but I'm wondering if it's as big a deal, as it might be, because if you live in a world where all you have to follow is the U.S. Supreme Court says, but you don't have to follow, any injunctions in lower courts, that's an easy deal.
Yeah, I don't view it as a tactical concession at all. I understand what you're saying, Anthony, and I think there's tons of people that range from arguers in good faith to full-on demagogues on the internet who will, cook up these crazy theories about how actually there's no authority for the courts to do anything at all, and because there's no enforcement mechanism, and judicial power versus executive and legislative power and all that stuff. But really, when you look at how the government's acted in court, it's never taken any of these radical positions yet. It's hinted at some occasionally, but fundamentally it's still agreeing that Marbury versus Madison was correctly decided and that the Supreme Court does get to decide constitutional questions. It's been more wishy-washy on the lower courts. But even then, it's impossible, I think, if they concede that the Supreme Court gets to adjudicate the constitutionality. I mean, if you look at Article 3, the judicial power resides in the Supreme Court and the inferior courts. It's not as if, from the perspective of constitutional power, there's some special power about the Supreme Court, insofar as you're looking at something other than whether the Supreme Court prevails over district courts or the circuit courts.
Yeah, the other interesting, just completely out there things from the oral argument to me were Justice Alito wanting to be the only justice on the court.
What?
He was talking about how, the district court judges, think that they're kings. They're not being challenged by colleagues sitting next to them, and so they're issuing these universal injunctions. He was talking about it as a critical thing that, the district court judges think they're really smart and they don't have anybody to push against them. But I think part of it was if it was only me, the only justice on this court, all the wonderful things I could do.
I suppose.
And also, In terms of Justices Sotomayor and Justice Jackson, I think that they kind of fully understood that they weren't just talking to the advocates and to the justices, but they were also talking to the general public. And I think they came very prepared for that, right? Like Justice Sotomayor very much wanted to lay out, like, here are the cases that essentially you're violating on the merits, right? Or imagine if this were an executive order on the Second Amendment banning guns. Those kind of things, I think, were designed much more to connect with regular people. And with Justice Jackson, when she talked about, catch me if you can, right? The rule that got played a lot in just like regular media. So people could understand the consequences of this beyond just the technicalities of universal injunctions. I thought that was really interesting too, kind of almost the court entering a new era. Where people are paying closer attention.
Along the same lines of the new era, it's interesting to see. I mean, I think there are bad actors on both sides and good actors on both sides, but it's interesting to see the enormous dichotomy when you look at, social media of like me. I'm looking at this stuff and I'm seeing like, it's clearly the executive branch that's engaged in bad behavior. And it's weird that for me, given what I do at IJ, my general frustration with our court systems and all that I've become like rah-rah cheering for judicial review and all that over the past 6 months. But there are people on the other side who are watching the exact same things play out, sophisticated, intelligent people with good intentions, and their reaction is exactly the opposite as mine. So it's been interesting to sort of come to terms with the reality being so fractured that I can see something that seems to me to be so obviously in favor of one side, and other reasonable people can look at it and be fully persuaded that the other side is doing the bad thing. And there's obviously a lot of noise in the data, but it does feel like a moment in time where it's not so much an ideological division as it is just a perception of reality division. And I don't know what to do with that.
Well, I mean, some of it too is, especially if you're a little bit more of a casual observer and you're not reading the briefs or really drilling down on the exact facts of, if you're talking about deportations, about what was alleged and what process was given or no process was given. Yeah, I can see people easily being confused by that. And I get confused about all this stories that have happened and all these cases that have happened. Sometimes I have to step back and be like, make a chart, right, to figure out which is which.
And so much of this is stuff that Anya and I have had to grapple with through the project because, we're talking about things like due process. Obviously, we're talking about sort of abstract procedural aspects of the way that our constitutional system works. And it's really hard for people to latch onto that stuff. Like the merits of, does this word mean that this thing can happen or that thing can happen? That's something that people can sink their teeth into. But the idea of focusing on process and saying, well, it doesn't really matter if someone's doing something illegal or criminal. What matters is that they got a fair process or that they got notice and an opportunity to be heard or whatever. That is something that doesn't immediately strike a chord with regular people. It's the same, this is why it's often so successful, in government power grab situations to say things like, well, if you've got nothing to hide, what are you worried about? Or you're like, yeah, everybody get in the backscatter radiation machine now. It's like, and I'm not one of those libertarians who insists on the pat downs. I'm sorry to disappoint some of our listeners. And I know some of our colleagues are those kinds of libertarians. But the point is, like, these little bites, it's really easy to tell people like, hey, yeah, you know what? Everyone hates taking their shoes off at the airport, but we really think it's worth it because of some, unclear connection to something bad that might happen.
Waste, fraud, and abuse.
Yeah, exactly.
And just keep repeating waste, fraud, and abuse.
And in a fundamental psychological way, I think it's the same as like any other sort of superstition where it's like, oh, Anya and I are cavemen 150,000 years ago, and like there's a storm and we like walk around a stick 3 times and the storm ends, and then we've convinced ourselves that every time it storms we need to walk around a stick 3 times. And it's like one time there was a correlation and the rest there wasn't, but that's good enough for us to latch onto. And I think we run into those same sorts of the brains that were there for us 150,000 years ago are still in our heads. And so that's something we just have to struggle with as part of the human condition.
So Anya was struggling with a couple recent actual opinions not that we're waiting on, that I think she was wrapping her head around. One was, so I can't remember the titles, but one was about the cop who jumped on the car very unwisely.
Yes.
And there was another one too.
Yes. So I'll let Patrick cover the cop case, Barnes versus Felix, since he mooted the guy who got the victory, Mr. Zelensky. I, of course, am partial to him solely because of his last name. Mr. Zelensky. And I will cover
Ukrainian pride there.
Ukrainian pride, yes. And I will cover a case that we actually discussed before with a guest, Isha Anand, but I'll let Patrick talk first.
Yeah, so Barnes versus Felix, like Anya said, was argued by Nathaniel Zelensky, who also then mooted me for Martin. So it's just bad penny stuff at this point.
That's so nice.
Very sweet. He had to fill in for his brother, actually. But I was happy and appreciative nonetheless. And so that case came out of the Fifth Circuit, and the question was whether this Fifth Circuit rule that assessed the reasonableness of force at the moment of the threat only could stand. And so, the Supreme Court itself and all the other circuits in assessing the reasonableness of any use of force look to the totality of the circumstances. So you're like, well, why was the cop there, and was it dark out, and did he think the person had a gun? And you're looking at it from the police officer's perspective, and then you're deciding, okay, well, maybe it turned out that the gun was, a water pistol, but it was dark outside, and he was looking for someone who had just killed a person, and that's good enough. So this was a reasonable use of force. Well, in this case, a police officer pulled someone over, and as they were walking up to the car that had the door open, the car tried to take off. The officer jumped kind of into the doorwell and then shot the person because at that point he was in danger for his life, or so he said. And the Fifth Circuit basically takes the position that the moment of threat is the only thing that matters. And so basically we're going to look at the moment you pulled the trigger, almost like when a taser goes off. It's got the video camera inside of the taser. I don't know if people know that, but tasers usually have video cameras inside them. And so you see the front blow off and the taser prong shoot out, and now you've got like 5 minutes of video that's about to be captured in the taser. And so that's kind of how the Fifth Circuit just sort of takes a snapshot at that moment and says, well, at the time he pulled the trigger, he was hanging onto a moving car that was right next to this concrete center of a highway, and so then it was reasonable force. And the Supreme Court said, no, you have to use the totality of the circumstances. Now, that doesn't mean that the plaintiff in that case or the estate will actually prevail. It just means the Fifth Circuit has to do the analysis and say, like, well, let's consider all the facts and was it reasonable given that the police officer is the one arguably who jumped into the car. Now, I think the police officer says, well, I didn't really have a choice because I was going to get dragged down the highway if I didn't do that. And so it can go both ways. But the point is, there's not a simple line that can be drawn, which is what the Fifth Circuit had started doing. And it was doing this in a way that was going to result in, if it hasn't many times already, ridiculous applications of force where, the police officer, this is kind of the quintessential counterexample, creates this volatile situation that wouldn't otherwise exist and then reacts to it using some sort of lethal force. In the same way that, like, private people, you're not allowed to start a fight with someone else and then escalate the fight by killing the person because then you say, well, I was acting in self-defense. And so there's similar principles at play, but the Barnes ruling was a good one, and it came out really quickly too, which is another thing that...
Yeah, I think part of it had to do with the government kind of walking away from the Fifth Circuit position too.
Right, yes. The government wasn't doing much to defend the rule. It was doing what it does oftentimes in these bad cases, and what the federal government did in Martin, which is just say, well, the right result was reached here, and so you don't really need to address this issue.
But no amicus in this case, right? Unlike your case? Like that was appointed?
Oh, correct. Right. Yeah. They held on to enough of it that they were, because the point is that the underlying decision is being defended, and that's what the government did in this case, but to no avail. And so now they'll go back to the Fifth Circuit and maybe the district court and see what those courts do with the new rule, which is actually just the old rule.
Yeah, exactly.
and apply it to this case and decide then whether the case can move forward or not, which another thing that I thought was noteworthy is one of the things that Nathaniel and company used in that case as a buffer, and this is kind of the mirror image of the alternative remedies thing, is he said, well, there's also qualified immunity. And so it very well may be that qualified immunity would shield this officer. And so you don't need this moment of threat test. You're kind of telling the court, like, hey, even if you agree with me, there are already other mechanisms that could get rid of it. And the reason that it's noteworthy is that the Supreme Court didn't use that as a crutch in its decision, which it often does. It often says, at the very end, but that doesn't mean that the defendant can't claim qualified immunity or something. It usually calls it out. And it didn't call it out here. Now, the defendant will raise that issue, I'm sure, on remand. But I thought it was noteworthy that the court didn't underscore it for everybody.
Although just because it didn't call out doesn't mean that's not what was happening in the back of their heads. Sure. I think that's an interesting thing with qualified immunity, that in a way it provides a little bit of a breathing room for the justices or even judges below to kind of say, okay, we almost like get a mulligan here. We get to say there is a constitutional violation, but we still might also, protect the cop who will eventually get qualified immunity.
The bad man won't win.
Right.
Yeah, it is though. It's one of those weird things about qualified immunity that we run into all the time, where we talk to people who are very sophisticated people and strategizing about cases and public interest stuff, which is they think like, oh, well, this would be a huge vehicle problem for your cert petition because the existence of qualified immunity will suggest that, the court shouldn't address the merits of the constitutional claim. But we've seen the court.
It's almost the opposite.
Exactly. Yeah. The court does it all the time. Like it did this in St. Louis versus Lombardo or whatever that case was called. And it's done it repeatedly, where instead of addressing QI, it just sidesteps it and says, we're going to reach the merits here. And if that implicates qualified immunity, you guys can sort it out below. And then maybe we'll talk about it later. Again, we saw that in Torres versus Madrid, for instance. And so I think it's
Tanvir versus Tanzine.
Yes.
Yep.
Yeah, I think it's just one of those weird things that's unique to qualified immunity, where in many other analogous contexts, this would be a huge vehicle problem, and the Supreme Court would never take a case to address the merits if there was some, sort of ancillary procedural mechanism to get rid of the case. But for whatever reason, because of qualified immunity and how pervasive it is and how weird of a doctrine it is, they're willing to take the cases up.
So going back, I just want to tangent a little bit, going back to our earlier discussion. You said the government held on to enough of the position in this case that they didn't have an amicus appointed, which is pretty rare, but it did happen in your case because, long story short, in Martin, the 11th Circuit had a rule that was so totally bonkers that the government doesn't even defend it. And for whatever reason, the court still wanted someone to brief it. And so they got an amicus appointed who then argued. So now you've gone through that whole process where you're not just against the other side. It could happen in any case, right? In this case, it's a case against the federal government. And then you also have this amicus that's against you. And I guess in the government's eyes, it's just kind of a free-floating, like kind of ally, but it's mostly probably annoying. What is your thought about that setup, that experience? What's it like having this third, amicus, but way more than a regular amicus, like you just get in a normal case?
Right. So I think in Barnes, actually, some of the reason why that didn't happen is because the government was a lot mushier in its running away from the standard. And by the time it got to the merits, the government did back away from the standard. But I think at the cert stage, it hadn't. And in our case, at the cert stage, the government was like, no, that supremacy clause issue is crazy. We're not defending that, but they were right for the wrong reasons, basically. And I think it's, as far as I'm aware, it's just completely standard operating procedure. If there is a question that's actually presented that one party simply is not going to defend, the court will appoint an amicus. And so there were a couple the second half of this term where the court did that because nobody below was willing to say, yeah, I think the 11th Circuit did the right thing on this doctrine or whatever other circuit it might have been. It's interesting because one problem with it when you had a situation like ours where there are two QPs is fundamentally then you're working on a reply brief you're stuck with your 6,000 words and you're, instead of responding to 13,000 words, you're responding to 26,000 words, which is a lot. I mean, we're talking about over 100 pages of briefing and you've got, 20 to respond. And you're also kind of like, and we played it this way and it turned out to be right, which was we don't think the Supreme Court's going to take seriously this issue. We didn't think it was serious to begin with other than it needed to be corrected. But still, there's always this worry in the back of your mind, which is like, oh my goodness, like what if that is the thing the court really wants to focus on? And so all the rest of this is misplaced and then you've just sort of placed your shield in the wrong spot and you're about to get hit. And luckily for us, the court didn't take any interest in the first question presented, and everyone sort of took it as a given that it was completely ludicrous and silly. Even though I think the amicus, Christopher Mills, who is a private attorney who was a former Supreme Court clerk, did an excellent job,
Yeah, for what he was given.
Making lemonade out of the lemons. Because it was like, when reading his brief, it seemed much more serious than I remember reading the 11th Circuit's opinion and being like, what the hell are they talking about? And it was really one of those things where we read the opinion and we were like, I don't know if we should get involved here, because we were like, it can't possibly be as silly as we think this sounds. And then we dug into it and are like, no, it's as silly, if not more silly than we thought. And so sometimes those issues make their way up to the court, and this is one of those. And so we'll see what the court does with the meat of the rest of the case, because much of the fight was on the other QP. And the disposition of what will happen in the case could depend on that, and will not depend on this supremacy clause bar.
Do you know if, I mean, it happens so rare. Like you said, it did happen another time this term, but do you know if often you get more briefing, whether you're responding to the opening brief or it's a reply brief situation? Is it usually just like, you got to respond to both, same number of pages, or can you ask for more? Like, are there guidelines?
I think the standard is that you don't get more, and I think the rules are pretty hostile towards requesting additional words or any sort of extensions for the reply briefs. I'm sure there's some weird outlying scenario where you've got like multiple amicus briefs that are going to make it impossible for you to respond or something, but I'm not aware of any instances where you're allowed to, enlarge the number of pages. And you see this too in the courts of appeals, where you have, two parties, like, let's just say you had a city and a police officer, right? And they each get to write a whole brief. And so they still end up with this double number of pages. Usually, this is another piece of advice for attorneys, is usually if you're writing like voluminously on something that you could write in fewer pages, you're doing yourself a disservice, mostly because even though you're dealing with very smart judges and clerks, people's eyes start to glaze over after page 50 or 60 or 70. I have friends who do employment work, and they're telling me about their 187 page brief. And I'm just thinking, like, I understand you have to make your record and all that, but the brief itself can't possibly be compelling enough to hold someone's attention for 200 pages.
I was involved in this taxi litigation we had in Chicago, where the Uber was not involved, but it was all because of Uber and Lyft. And the taxi cab companies were suing the city, and then we represented these rideshare drivers who were on the same side of the city. And the briefs were just absolutely extraordinary. They weren't 187 pages, but they were well over the maximum. And it was in district court. And I think the district judge was just like, I'm not going to read it all, but fine. Yeah, you want to file more pages? Fine, go ahead. Mm-hmm. And so they'd always get like allowed to go way over whatever the heck the rule is there for however many words you can have. And then it didn't do them any good. They lost. It was like a 2-page order.
No, we did that. We ran into that in King in the district court. The government did its It did separate briefing for the FTCA on behalf of the United States and for the individual officers in their own capacity. And on top of that, it got like a 20-page extension for one or both of the briefs. And so they wrote like 150 pages total between the two. And there was another defendant who got settled out of the case who filed a briefing as well. And we just responded in the normal page limits. And I think that was the right choice.
Yeah.
But wait, just to what you guys were talking about, it was really surprising to me that the government and the amicus in the Martin case got equal amount of time, right? They basically divided the argument. So 15 minutes for the amicus, 15 minutes for the government, which was kind of interesting because, the government obviously was arguing a much more, a position that had many more interesting back and forth between the advocate and the justices. And the amicus, he basically, it lasted 5 minutes or something? That there weren't that many questions. But I think part of it probably is because you have this seriatim function at the end of each argument. So they're like, okay, fine. as the government, we're going to get 15 minutes, but then we can answer all the questions that are still lingering during the seriatim.
Yeah, and if you need to see like illustrations of that, listen to the Universal Injunctions Trump versus Casa case, because in the seriatim, the reason why that case was argued for like 2.5 hours is because it felt like an entirely separate full argument as each of the justices went through with the litigants.
Yeah, but with medical marijuana versus Horn, I just want to really give shout out to Isha Anand. She came to Short Circuit to talk about this case right before she argued it. And we have an update for our listeners. I think it's been about a month, although time is a strange concept at this point. But she won the case with 5 justices ruling for her, even though she was a respondent, right? And one of the justices, Justice Thomas, he felt like it's not like he disagreed with Isha. It's just he felt like the petition was improvidently granted. But it's an interesting case involving an interpretation of the RICO statute, and we were very happy to see that the court interpreted that federal statute generously. And we hope that they do the same with Martin and interpret our federal statute, FTCA, generously.
Amen.
And Justice Kavanaugh, if you're listening, you really seem to be interested in this idea of the term of art in the RICO statute. There is a similar concept that we put forward in the Martin case. So
That's right. Yeah, and also thank you to Isha and the Stanford Clinic for mooting us in Martin too.
Totally. Yes, they are such good friends.
Yep.
Lovely. Well, yes. Thank you to the Stanford Clinic, and I am trying to see when Isha did come on. I remember it was earlier this year. We'll put a link in the show notes to it.
Yeah, her case was one of the first argued this term.
Oh, that's right. Okay.
They have another FTCA case coming up next term, Conan.
Yeah, Stanford does. Yes.
What's the twist on that one?
It's about the postal exception to the FTCA, and that one is the case, if I recall correctly, is one where someone alleges that the post office stopped delivering things because of racial animus.
I see.
And whether that falls into the delivery of mail exception to the Federal Tort Claims Act.
Does that have to do with what you talked about, maybe an oral argument even, Patrick, about the mail truck crashing into your mailbox and whether you can sue about that? Or is that just like some whole separate?
That's a separate thing.
Okay.
It's funny because so much of the Federal Tort Claims Act is built around mail trucks. That's like the quintessential thing that they were really worried about. I guess postal drivers must have just been out of control in like 1948, like just...
Well, or planes flying into buildings, like the 1946, I think.
Yeah, that did happen too.
45.
Yes.
Yeah.
1945.
45. That's right. And the amendment was passed in 46.
Yeah.
So Isha was on Short Circuit January 31st, Short Circuit 361. So we'll put a link in there. That's when she was last on. She's been on a few times.
Yeah, I was going to say.
So to close... Curious what you guys are listening to, reading, that you want. You think our listeners would enjoy, law-wise and otherwise?
Oh boy, I got a dark one.
Okay.
Oy.
So I've been trying to find some decent, new movies that aren't just based on IP, right? Like I can't watch another superhero movie at this point. I don't want to watch. Jurassic Park 83.
I see there's another Superman coming out.
Anyway, so I've been avoiding that.
There's like 10 already.
I've been avoiding that. So I had a friend recommend to me a couple kind of movies that are in the sort of horror thriller genre. And when he recommended them, I didn't know this, but then I came to find out one was French and the other was French-Canadian. So both of them were in French, at least depending on who you ask. And the one that's the legal drama aspect is a movie called Red Rooms. And it's a very dark movie about a woman who is obsessed with this French-Canadian alleged serial killer in his trial. And so a lot of the case takes place with her in the courtroom watching the trial And it's just very interesting, as someone who's coming from the American legal tradition, just to see like how the trial is being played out. So they have the defendant who's in like a glass box, very like Russian, if you've seen those guys when they have to go. He's chained up, he's in a glass box. So unlike America, where we like don't want the jury to see handcuffs or orange jumpsuits, like they are not concerned about that apparently in Montreal. And I actually don't know how similar this is to the Anglo Canadian system, so I can't speak to that. But the judge and the jury, they all sit directly across from the podium, and the witnesses come and speak at a podium. So they're not sitting like next to the judge. They're speaking to the judge and the jury, and the lawyers kind of sit facing each other in the middle, and they wear robes. And so that was not the most interesting thing about the movie, which again is very dark because it's about serial killing and snuff videos. But watching the courtroom part of it was just interesting for me to see like, oh, this is so different and so foreign from the way that it works in America, just by the way that it's set up. And I can, speak to the procedures and all the rest of it. But it was a very good movie, but come into it with the understanding that it's not something you should watch with your children.
Shout out to Canadians, by the way.
Sure.
Because I was watching labor debates, right, when Mark Carney was running.
As you do.
As I do. And they had one in French and one in English. And like all of the freaking candidates could speak French.
Well,
then the following day they did it in English.
I heard Mark Carney's French was not the greatest.
No,
So
and the debate was really
impressed.
weird. I think all of them like have that French is like not their, dominant language. But yes, Mark Carney especially struggled. But it is amazing that they can actually debate in a different language. So that's pretty cool. That's a cool country.
Yeah, I feel like this is just Anya. Anya is just humble bragging that as a first language Russian speaker, she's able to go argue and win in the Supreme Court of the United States.
I don't speak in one language without an accent. There isn't a language that's left where I speak with no accent. So, and yes, I was talking to Eugene Volokh and I'm not humble bragging.
She's just bragging.
Yes, exactly. Thank you very much. Like a week ago or so, and his Russian is actually better than mine. So it's the price of assimilation, I suppose. I really don't speak any language well anymore, including Russian or English or Ukrainian or Kyrgyz or whatever it is, you name it.
I think you speak English, well good. I think it's okay.
She gets by.
I'll take it. But I do have a shout out for a book. I just finished it called The Gatekeepers, and it's about chiefs of staff for various presidents, starting with Nixon and going all the way through Reince Priebus in the first Trump administration. And it's kind of helped me develop a whole new appreciation for the kind of job that they do and that the role that they play in, making an administration successful or making it not successful. It's something that I haven't really thought much about, but apparently chiefs of staff are a big deal.
Yeah, I was watching some bad Netflix series. It wasn't too bad, but it wasn't great. About, some sort of FBI agent thing. And the chief of staff was so heavily involved in like all these secret operations. I was like, is that true?
I think with Nixon, it actually was very much true. Yeah.
I mean, chiefs, that's notoriously, right, a huge burnout job because it is so demanding. That's why presidents often have so many chiefs of staff.
That's right.
Through their term. Cool. Any legal stuff for legal listeners they should read?
Legal stuff for legal listener. Well, so here's a shout out. I'm full of shout outs today to Andy Oldham and his concurrence in Villarreal, the latest iteration.
Judge Oldham of the Fifth Circuit Court of Appeals.
Yes. He wrote a wonderful concurrence. I wish it were a dissent, but he wrote a wonderful concurrence in the latest iteration of the Fifth Circuit dealing with the arrest of a journalist, which was clearly retaliatory. Where he explained that when it comes to qualified immunity, especially outside of split-second decision-making, that the concept of fair warning does not require a case specifically exactly similar on the facts. And he also talked about how when you're looking at a case and whether there was fair warning, you should focus on the actual right at issue rather than technicality surrounding that right, like a remedy, for example. Often we see courts getting lost, and what kind of precedent exactly are we looking for? So he kind of clarified that for those who were interested in reading that, it's a good one.
And we talked about that opinion on Short Circuit a couple weeks ago. We were kind of confused, as I'm sure you guys were, about why the Fifth Circuit did that after the remand from the Supreme Court, but it's going back up, right? So
yeah. And on exactly the same issue. That's the weird thing.
Yeah.
So yeah, they did not do what the Supreme Court essentially asked them to do.
Well, yes, we'll see how that shakes out. If people are super nerdy and are interested in this, also Daniel Nelson and I have a paper forthcoming in the Harvard Journal of Law and Public Policy called Section 1983 Still Displaces Qualified Immunity, that talks about the lost notwithstanding clause in the history of Section 1983.
Shameless self-promotion.
That's right. I'm now bragging. Which very clearly shows that when Section 1983 was written, Congress was intending to displace any sort of common law immunities and defenses. And I think we make a very compelling case that will hopefully be one of the many bricks in our wall to put up around qualified immunity in the hopes of making it into a cask of Amontillado situation.
And I won't ask what that is, but it is a heavily downloaded article. It was just behind an article about Cthulhu I saw on SSRN.
Yeah, I didn't know this was even a thing, but I got like random emails a few times saying that we were in the top 10 downloads list for both legal history and constitutional law. But I think they only do that for like the first month or two that it's posted. So now I'm just in the
well, I think it looks like, so I've gotten those for some of my articles, including ones where top 10 was, maybe it's top 8 because there's only 8 overall in that subject. So don't, get too bent out of.
Well, they were full 10 here. And the other thing that made me, I'm trying to brag here, Anthony. The other thing that made me realize it was real was I looked at the list and it was like heavy hitters on the list. I can't remember, it was like Kurt Lash and Will Bode had papers on these lists.
I think what it is like the your downloads in the last like week or month or something. So after a while, the old ones don't count anymore. So.
Well, I'll take it. I'm only a part-time academic,
Flaunt it while you got it. So I got a couple books that I made my way through recently that they recommend to the listeners. So one is this is if you like book collecting, like you're one of those people who like walks through a secondhand bookshop and just kind of your eyes like, ooh, that's neat. And you pull stuff off over and over again. This great book called Jane Austen's Bookshelf. So I know a few episodes ago, I was saying like I'm a now converted Austinian because I like thought Jane Austen was dumb. And then I read all the books last year and I was like, oh, this is actually super cool. So this is a follow-up to that where this woman who's a used bookseller. So, she was actually on Pawn Wars, that show that ran for a while. Pawn Stars, that was it.
It's a play on words.
I would hope so. Rebecca Romney, her name is. And anyway, so she'd be on that show talking about old books, but she goes into these predecessors of Jane Austen who were women writers of the time who are kind of forgotten now. And
Fanny Burney.
Yeah, that's one of them. Yeah,
yes.
Fanny Burney.
She is amazing, and I can't believe we don't know more about her.
Yeah, Maria Edgeworth, another. I'm working my way through novel of hers right now. So anyway, Sue, if you like used books, it's super cool. So check it out. And then, a cousin of mine is a mystery writer, and I hadn't read any of her stuff till recently. And I read one recently, and it was just super fun, like mystery, true crime. Well, actually, it's not true. So it's not true crime, but it's crime. And anyway, you should check it out. Missing Molly is the book. And she goes by a pen name, but it's Natalie Bartelli is her pen name. But really Missing cool. Molly, she's written a bunch of other stuff. So you guys should check it out. Increase the family downloads. So
let's do it.
Yeah. So
load your Kindle up with that Via Real Concurrence, my law review article, and Missing Molly.
Right. And Baby Ninth Amendment's my book, because you can get that for free.
Of course.
kind of like Patrick's article. It's just as good too. All right. Well, thank you guys for coming on. We've been talking a long time, so we're going to stop. And, that's just like your unpublished opinion, man.
Go and get some hops, get myself a gun and shoot myself a cop. I ain't had nothing but that.